SJC-11893, Commonwealth v. John C. Depiero.
Good morning, Chief Justice Gantz. May it please the court, Jane Prince on behalf of Mr. Depiero. I'm here today with co-counsel Randy Chapman, who handled the trial and the motion at the district court, as well as Mr. Depiero. The central issue in this case that's raised by the appeals court is whether or not Massachusetts law enforcement can stop a motor vehicle based on an uncorroborated anonymous tip of a single instance of erratic driving. I would suggest to the court that the age-old application of Aguilar Spinelli requires that this court say that the tip, which is a bare-bones tip, does not satisfy the reliability prong or the basis of knowledge prong. As the court considers the application of those well-settled principles, I'm also asking the court to limit the Commonwealth to those arguments properly raised at the motion hearing. The thrust of the appeals court is that this tip is reliable because it's an excited utterance. And I would suggest to the court there are many problems with that suggestion. The main problem is that there is nothing to corroborate this tip. But before we get to that, the other problem is that this particular excited utterance theory, which I would argue to this court is a novel theory of reliability, was not raised at the motion level. In fact, at the motion court hearing, defense counsel argued that it wasn't reliable because it wasn't corroborated. The Commonwealth, in turn, argued Commonwealth v. Davis, which, as I view it, is the emergency doctrine. There was no comment on the record about either of the cases suggested by the Commonwealth that support this, Anderson or DePina. There was the court's attention was not directed to the way the tipster spoke. In short, there was no reason to think that an excited utterance theory was in play.
Now, I'm sorry, you go ahead.
Well, if it's an emergency, why isn't it an excited utterance? I mean, you see a drunk driver swerving all over the road, your own safety is at risk.
Right, but I think with respect to this excited utterance theory, Your Honor, we did argue that it wasn't an emergency, and we argued that it wasn't an emergency based on the nature of the tip relative to Commonwealth v. Davis and Commonwealth v. Lubajewski. Both of those are appeals court cases that both say that the tips in those cases were not reliable, and therefore they were evaluated under the emergency doctrine.
Yeah, but here, the caller said, you got a drunk driver on Memorial Drive near Harvard Square, but he's swerving all over the road. Doesn't that suggest that this person is observing this thing firsthand, witnessing the thing firsthand?
I would agree that it suggests that it's a possible firsthand observation, but I guess we had the benefit of listening to the tape, and this is a driver who says, in my view, there's no findings of facts with respect to that. It was a very calm call. Hey, you got a drunk driver, you know, and it's clear from the nature of the tip that it's a conclusory allegation of drunk driving. I think swerving can be attributed to many different causes. Someone on the phone, reaching for something to eat.
Yeah, but if it's swerving all over the road, you wouldn't disagree that that might create a reasonable suspicion that the reason was drunk driving.
I think that in this case, you only have this
at
one.
At 2 a.m.
I'm sorry?
At 2 a.m. on Memorial Drive.
Okay. I think in this case, Judge, it's, you know, even if you listen to the way the dispatcher handled it and the judge found, they described it as an erratic driver, and then the judge found that it was a civil motor vehicle infraction. I think swerving all over the road can mean a lot of different things to a lot of different people, and if it's one little swerve or if it's this ongoing, you know, swerving completely across lanes, you know, where other people are driving out of the way. And I think that's what's important about this tip, is that there's very little detail. You get this one little blip about how the operator was operating on weeks by the Weeks Bridge. But in Lubajewski, for example, that had the caller called twice, and it's clear from that that operator was following them for an extended period of time. So I think that's a dramatically different analysis, and I think given the ambiguity of what a swerve means, if that's all you've got, I don't think it's enough to infer.
Can I ask you, I don't quite understand the timing of the 911 tape, because I take it that the trooper he just heard the dispatcher, right?
Correct.
So does that matter that, in other words, if the 911 call uses the phrase drunk driving,
Right.
but what the dispatcher says is erratic driving,
Right.
right? Does that matter to you? That, in other words, or do we look at do we go back to the 911 tape?
I think in this, you have, actually the 911 tape is very interesting if the court listens to it. You have the 911
it?
caller. I'm sorry?
Do we have it? Apparently, it's not in our record.
It's in the district court file. It's not part of this
We
record.
could get it, though.
It's easy, yeah, it's part of the district court record, yes. With respect to the way the calls are made and Your Honor's question about timing, there's no date or timestamp or anything on the actual tipster's call. The only information, so the tipster calls the Framingham transfers it to the barracks, and the barracks transfers it out to whoever. So I don't know how long that process takes. But with respect to, I think in terms of what I know that hearsay is permissible in the context of a stop, but now you've got totem pole hearsay because the tipster called Trooper Usum. Trooper Usum conveyed it to a dispatcher. Dispatcher conveyed it to the trooper who's on scene. So now you have these multiple levels, and the trooper's knowledge is you got an erratic operator. So I would say in this case that it does matter.
But now you also have an erratic operator who, at the time, the police knew was on probation for a conviction of drunk driving.
Yes, Judge. And I would suggest to the court that Aguilar-Spinelli, and actually Spinelli itself, helps us understand how to evaluate that piece of evidence in the context of a tip. I would say two things. One, since we don't know who called, and that's clear, this caller is not identifiable at all. You don't know if the caller knows this person or doesn't know this person. So what better way to get someone in trouble than to say, oh, the person who's on probation?
But how would, well, the caller didn't say that.
No, I thought that was
the police.
No, absolutely.
The caller said that?
No, excuse
It
me.
was the police.
No, it was the police who said
Okay.
that. But I'm saying if a person with animus towards someone knew that they were on probation, what better way to get them in trouble?
Well, except that it seems to me the problem with that is, okay, so a police officer responds to a false dispatch, a dispatch containing false information.
Yes.
He pulls behind the driver, and he doesn't see any erratic operation. He's not going to get in trouble.
Well, that's what happened in this case.
Well, that's not what happened in this case, because he didn't pull behind him and follow him.
Well, what happened?
He arrived at his
observed-
house.
Right. No, but he observed him operate that vehicle, and he observed him operate it absolutely fine. He observed it coming down the street.
trooper.
The trooper made observations that
But
discredit.
if the 911 caller
Yeah,
is saying you've got a drunk driver and here's the license plate number,
right.
what would most likely happen is that the person would get behind, the trooper would get behind the driver,
Correct.
or in ideal circumstances, he would follow him and see that the person wasn't weaving. So how could they get in trouble? How could he create a harassing situation for somebody who's in fact not a drunk driver?
Well, I mean, what happened in this case is you have a trooper who didn't see.
No. In my hypothetical,
I'm sorry?
you make a false call. A 911 caller makes a false call
Right.
with the intent to make life miserable for somebody.
Right,
A police officer gets dispatched, ends up driving behind this person, this driver, and there's no weaving. He doesn't get in trouble.
right.
So how could a false call in these circumstances possibly create a problem for somebody?
Well, I think if you have officers who act outside the Constitution, which is what happened in this case, they didn't see any observations along those lines, but yet they still stopped the vehicle. So I'd suggest to the court that when the trooper made that call that he was going to stop, he didn't have enough information at that time to make the call. He acted outside of the Declaration of Rights. So
You don't think the information about the person who is driving the car that's reportedly driving in an erratic fashion, that the registered owner of the car is on probation for operating under, corroborates the tip?
no, I don't. And I think if I could get back to my original point, I think it's a factor to consider, and this court can consider it as a factor. But when you look at Spinelli and the cases the Commonwealth cited, as well as the ones that I cited, and those would be Germain and Gomes, they all say that this is a factor, but it's not the factor that pulls it over the line. It's a factor to be considered with other factors. And when you look at Germain, which is what the Commonwealth cited, that was a very detailed tip that had a lot of extrinsic corroboration. That was a probable cause analysis. I believe it was a robbery at Zayre's, and store employees had reported the theft and had gave very specific information about what the person looked like, the details, how much money was stolen. And after that, there was an anonymous tip that said Mr. Germain was the one who did it. Again, it gave specific details. And then after that, the police not only corroborated the tip with the details that they knew from the original caller, that they had people that they could speak to directly to corroborate the criminality, I guess is what I'm really trying to say. And then after they got that tip, they did further work to find out that from the landlord that, in fact, Mr. Germain was seen on the date of the robbery. He had a lot of 10s and 20s, and there were several other things that the police corroborated through their own observation. But right now, you just have sort of little pieces of information that really don't go together. And even with respect to the Commonwealth v. Gomes, which that's a reasonable suspicion Aguilar-Spinelli analysis, how they analyzed the record there. That was a trooper with a lot of experience with respect to narcotics. They saw a particular person who was, quote, known to the police. And then there was a lot of information with regard to the trooper's own experience and how narcotics possessors and dealers acted. And he saw, with his own eyes, the suspect put cocaine or some drug in his mouth. With his training experience is how narcotics dealers acted when they were getting caught. So when you look at Gomes, when you look at Germain, and then you go back to Spinelli, it's not specific. It refers to reputation evidence. And it says that reputation evidence standing alone is not a factor to make up for an otherwise deficient tip. So while I agree that it's a factor in this case, it's not a factor that pulls it over the line.
Let me ask you here, if the police officer who went to the Belmont home and saw the driving up to the house, and that seemed normal and everything, if he'd waited a few more minutes and waited until this man got out and fell down on his face?
I think that's a different analysis, Judge. Yes, I do. If he had pulled over and walked up to the side, there had been no constitutional stop at that point. So yeah, I do think that's different.
Because falling on his face would have been even more corroboration.
Right, but he didn't know that when he put the lights
Right.
on.
Right.
With respect to the excited utterance, I would ask that the court reject that as I think it's very troubling in the Aguilar-Spinelli analysis that a tip can be, quote, self-corroborating. And I think...
Is there, we asked for briefing on the Navarrete issue.
Yes.
Is there really any difference between the appeals court's analysis of excited utterance and that of the majority in Navarrete?
Well, I think there's a couple of different important distinctions. One, obviously, is that Navarrete uses the totality of the circumstances test, and we do not use it here. With respect to, I think it goes back to why we have Aguilar-Spinelli here and not Upton. Upton is that impermissive, I forget the exact language, unacceptably shapeless and permissive. So, I do think they're a qualitatively different analysis, and I think that the tip in this case is substantially different than the tip in Navarrete, where in Navarrete they alleged a specific result from the way the car was being driven. So I do think there's a significant distinction.
Right, thank you.
Thank you.
May it please the court, my name is Casey Sylvia. I'm an assistant district attorney for Middlesex, appearing on behalf of the Commonwealth. Your Honors, the motion judge here properly denied the defendant's motion to suppress where the information provided by the 911 caller was reliable and it established reasonable suspicion to stop the defendant.
Do you press the point from Navarrete that we should infer that persons recognize that they're not anonymous when they call 911?
I believe I did address that in my brief, and I'll address that again now.
But I mean, you have the amicus, which says that the state police says you should assume that you're anonymous.
So,
And we
Your
don't,
Honor,
and we don't have the name here. So why should a reasonable person assume that the state police knows who they are when we don't know who called, and the state police tells people on their website, you should assume you're anonymous?
Your Honor, so I read the amicus brief with some interest. I thought there were a few points that actually were helpful to our argument. First of all, with regards to the FAQs from the EOPS website, obviously they're not in the record, but I did pull them. I think it's extremely obvious when you look at them in context that the purpose of these FAQs is if you're somebody that's actually in danger, that's having an emergency, they do want you to give as much information as possible. And when you read it in context, it's really clear that is what they're saying.
Yeah, but if you're, that may be what they're saying, but the point is, are we really going to assume that when people call 911 that they are going to be truthful because they know they can be, you really think so?
I do, Your Honor. I absolutely think so. I'd also just point out the other thing on the EOPS website is this wireless call trace procedure. That's also publicly available on the website, explaining exactly how officers can trace wireless phone calls.
Does the record reflect who called here?
No, it does not, Your Honor.
But there's no record of it, isn't that right? I mean, because wasn't there something about how the Brighton barracks doesn't keep this or something?
For whatever reason, the Brighton portion of the recording was not recorded or was not kept.
So we should all assume that which is not true?
So with regards to 911 calls, though, I think that there's actually really no dispute. Legally, they are required to be able to trace those phone calls. The Massachusetts CMRs also address that in addition to the federal regulations that require that 911, what they call phase 1 and phase 2, actually the 911 emergency management system be able to trace these phone calls.
And it can trace wireless as well as landlines.
They can, Your Honor, and specifically with regards to wireless, cell phone companies are required to provide geographic location information. So for instance, if you were using a burner phone, which amicus brings up, a phone that does not have subscriber information attached to it, they would still be able potentially to determine the geographic location of the person making that phone call.
So if I were to call 911 from Memorial Drive, 2 in the morning, they would be able to tell my phone number, the phone number from which I was calling, and therefore trace it back to the subscriber and the location from which I made the call?
Absolutely, Your Honor, and that's just...
That's not going through the phone company and getting a subpoena. You could just determine that from your own records.
So if you look at the website, it's clear that if you look at the website for EOPS, it is clear that the phone number is being recorded. There is information, the geographic location information has to be obtained from the cell phone company, I believe, although it's not via subpoena. There's a process by which they call them and tell them what's going on, and they provide the information, is my understanding.
But can't either a landline or a cell phone block the identifying information of the call?
They actually can't. Under the Code of Federal Regulations, that's in the Navarrete decision as well. That's one of the federal regulations is that they cannot block phone numbers. The caller cannot block their phone number when they're calling 911.
Does the record reflect that the state police routinely are keeping the names of these callers?
No, it does not, Your Honor. The record in this case is...
we have no record that you're in fact keeping, you have the potential to know who they are.
Right, that's correct, Your
But
Honor.
no record that says that you indeed are recording or identifying who they are.
That's correct, Your Honor. I think that it's similar to in Costa, where the individual is identifiable, though not identified. I agree that the record is less than ideal on this point in this case. I think as a general matter, though, I really would strongly urge the court to consider the use of the 911 system, even if for some reason you thought the record were lacking in this case, to consider the use of the 911 system in the same way the Navarrete court did, as being an indicator of reliability. There's one other thing I wanted to point out with regards to...
But if people have the blocking technology on their phone, when they dial 911, does that series of numbers automatically disable the blocking mechanism?
My understanding is that under the Code of Federal Regulations, that cell phone carriers are not allowed to allow callers to block their numbers. So if we're just talking about a normal blocking
So the blocking
mechanism,
technology doesn't exist in the cell phone. It exists
there could be applications
in the phone company.
Right, that's my understanding based on Navarrete and the Code of Federal Regulations.
So let's assume you have the capacity to do this, and it can readily be done. That doesn't end the inquiry, does it? It really, the whole reason why this is viewed perhaps as trustworthy is because the caller knows
Right.
that in fact they can be identified. So maybe you better get the word out a little more effectively.
Your Honor, I agree with that, and there's something, this actually brings me back to my point about what's raised in the amicus brief, which is swatting. They bring up swatting as if what this means is that everybody calling 911 is doing it, they're these false pranksters, when in reality we're talking about a very small handful of instances. Besides that, though, I think what that indicates, they bring it up about the swatting, I think what that indicates is that members of the public know that under ordinary circumstances, your phone number can be traced by 911. That's why they're using these applications to deceive the 911 system, or to try to deceive the 911 system into not knowing their identity when they make these prank calls.
You can't have it both ways. You can't say it's a very, very small
Well, it is.
minority and that
Well,
reflects that the general public
I think it's
knows
a
that.
small minority that actually engages in this. I really honestly find it sort of incredulous that the ordinary population wouldn't understand that when you make an emergency phone call to 911, given all the technology we have, given the fact that when I post a picture on Facebook from here that it will come up with my location, everyone can see that, given the fact that we're carrying around these GPS devices essentially in our pockets constantly, I just find it really hard to believe that given the state of technology, people do not understand that if you're in the middle of being stabbed and you call 911, that they can't find you. And in fact, I think that's the reason that we have the location tracking that we do, is because of instances like that.
So maybe state police should say, your call is recorded, we know who you are. But they don't.
No, what they say
And
is
they probably don't want.
they're actually required.
Because they didn't ask who they were. They didn't ask for a name.
Right.
Is it routine practice to ask for a name?
I can tell you from when I've called 911 on people I suspect drunk drivers in front of me.
People you're trying to set up?
I know exactly, the people I'm trying to set up when I'm, exactly. They do ask for your name. I think it's possible that it was in the second
You
part of
always
that
give a
recording
false
that was
name
not
when you're
recorded.
setting them up.
Exactly, of course I do. So they do ask for that information. If I had to speculate, and this is speculation, it was probably in the second part of that call that was not recorded.
So, okay, we get information, but there's not a time, is that right? In other words, it isn't like, I just saw him on Memorial. I mean, do we have any time, and do we know the time of the call?
The time of the call, we know based on when the officer responds to it that it's slightly before 2 a.m.
But the call in relation to the observation by the caller.
We don't. I think it's a reasonable inference when he says you've got a drunk driver on Memorial Drive, he's swerving all over the road, that's sort of a present sense impression. I think that the case law bears that out, both in Anderson and Depiero.
And then he provided the license plate number, right? Anything else? Color of car, type of car? I can't recall.
So the officer testified that the make and model of the car were also given. So it was the license plate number, make, model of the car. Then the officer lined that up with the address of the registered owner, went to that address, and then the person arrived in that vehicle within, I think it was about 5 minutes. It took him about 5 minutes to get there. A few minutes later, the defendant arrives, and he observes him driving for under a minute before he pulls into his driveway.
But observes nothing wrong with the way he's driving.
Right, and he really had a very short period of time, though, to actually observe him. And I think in the Navarrete decision, the court also points out that that drunk drivers may, for a short period of time, be able to maintain a lane when they see a marked cruiser in back of them.
But you have in the Navarrete case, the woman saying, he just ran me off the road, my trucker. Yeah, I mean, it just, there's a lot more immediacy in the message itself.
Your Honor, I understand what you're saying. I do think that is a little bit more dramatic, but I don't think that we should have to wait for somebody to be almost driven off the road or for an accident to occur in order to investigate a report of somebody swerving all over the road.
What exactly did the 911 caller say?
They said, you got a drunk driver on Memorial Drive. He's swerving all over the road. I have his plate number, or something
Okay.
very close to
So
that.
because, talking about technology, I mean, I think I've seen as many people swerve because they were looking at their cell phones.
Right, I personally think it's a fair inference when you say somebody swerving all over the road that it was alarming enough that it wasn't just a one-time, he swerved over the line.
That means that it was more than one swerve.
I think when you say you're swerving all over the road, I do think that that's what that means. I also think that the Navarrete decision also addresses that point, actually, about, I think it actually directly says that the Commonwealth or the state doesn't have to exclude all other innocent possibilities, like, for instance.
No, but when the police officer is following, ordinarily after you get a 911 call and a tipster, and the police do something to check up on it, they'd be looking to see how the person was driving thereafter, and if the person wasn't doing anything else, you can in fact rule out the other alternative of drunkenness and be more likely to say, oh, that was probably looking at the cell phone. And so here, what do you do when you're basically sitting and waiting? Now the lights are not on, right? So that there goes your theory about, well, he's driving more carefully because the police officer is there. If you have no reason to know that he actually saw the police officer there.
Again, I'm not terribly impressed though that somebody can manage to maintain a lane for under a minute. I mean, I think he's almost home
I don't
at
know
that
how
point.
long he didn't maintain the lane.
Well, the period that the officer had to observe him, though.
No,
And again, I think in Davis and
but that's all the more reason for it. That's the more weight than that's given to the tip, and less to what the police officer himself saw.
I'm sorry, I'm not sure that I understand.
It doesn't corroborate, in other words.
Well, it
His
doesn't-
observations
Don't
don't
corroborate.
corroborate.
It doesn't corroborate. I don't think it significantly undermines though either. And I think that there are a number of other cases, including the Davis case and including Navarrete itself, where the officer didn't personally observe the erratic operation. And I understand what you're saying, that it might be like, for instance, in Lubiuski, when the officer followed the defendant for some period of time and didn't observe any further erratic operation. That might be enough to sort of dispel the concern or dispel the emergency situation. But in Navarrete and in Davis, and I think again in this case, the fact that the officer didn't actually observe the erratic operation, I don't think means that tip is worthless or isn't worthy of being investigated.
I'm sorry, if you're not finished, you can finish
No,
that.
the only thing that I was going to add is that, like, I really think it's a very dangerous thing to say that an officer has to wait until he sees erratic operation that's been reported, because, I mean, the erratic operation could be that that individual hits somebody and kills them. I just don't think
So
that
you're
that's
saying
reasonable.
that just on the basis of a tip, somebody can be stopped?
I'm saying that on the basis of a tip in these types of circumstances, when a caller is reporting an alarming event it can be reasonably inferred is ongoing, that they're witnessing, and they use the 911 system to report it, and they're told that they're being recorded, and the officer corroborates some of the circumstances.
What did the officer corroborate here?
He corroborated just like in Anderson and in Depiero, he corroborated the direction of travel and the amount of time that it would have taken. So
Direction of travel from Memorial Drive to Belmont?
Right, he was headed westbound, and he arrived in Belmont at Cross Street within the amount of time that I think that you'd expect that he would be there. The officer said he didn't think he could intercept him successfully on Memorial Drive because the distance was so short, and then he arrived in the location where the officer would expect him to.
So that just confirms that it was the car that the 911 caller saw. That's all it corroborated.
And that, in fact, it took approximately the amount of time that you
So
would think
what?
it would from the Weeks Bridge on Memorial
That
Drive.
just shows that it was the right car.
It shows that it was the right car headed in the direction that for instance, what didn't happen is they didn't find him 5 minutes later in Framingham. They found him in a location
goes
just
to
like in
what?
Anderson and Depiero.
And that goes to what point? What is that? What important thing does that corroborate?
I think that it corroborates, again, the fact that he was at the location where
He was
The caller
observed.
said he was, that he was driving, and then he arrived in.
Okay, so it confirms that it was the car that the tipster said it was.
Yes, and that it was headed in the correct direction at the time he said it was, and that he arrived in that location, in the amount of time you'd expect him to.
And it was at 2 a.m., and there was information that he was on probation for OUI, and then the excited utterance.
That's correct, Your Honor.
Should we, how much, this excited utterance, I understand, I think part of your argument that, we can look to other things in affirming the decision below, but there's been no finding that it wasn't excited. Are we supposed to make a finding as to whether this was in fact an excited utterance?
I don't think you have to make a finding that it's an excited utterance in the sense that you'd need to for admissibility purposes. I think that's what Anderson says, for example. I think it's something that this court can make a decision on as a legal matter for these purposes. And again, I just want to remind.
Is it different? Is it excited utterance for admissibility different than excited utterance for these purposes, would you say?
Yes, Your Honor, absolutely. I think the Anderson case bears that out. I think it actually
But
directly says
Anderson,
that.
but it is a factual matter, and here you've got somebody who says, "What's your emergency?" That's what the answerer says, and the caller says, "Just a call," and then goes on to say, "You've got a drunk driver on Memorial Drive." There's nothing about the words or the situation in comparison to Anderson that they just seem so different factually.
I disagree that there's nothing about the situation itself. I think the fact that when you see
Drunk driving, that's what you're saying. Drunk
I
driving
disagree with the situation
is
itself. I think presented an alarming enough situation that the caller felt obligated to call the police at that point. I think that the fact that he called the police as he's witnessing this suggests in and of itself that this is something that's alarming enough that you feel that you need to bring it to the police's attention right then. It's not like he waited till he got home 3 hours later and said, maybe I should give the police a call about this. And again, one thing I do just before I wrap up, I do want to remind the court that the standard we're talking about here is reasonable suspicion. We're not talking about beyond reasonable doubt. We're not talking about probable cause.
Before you leave reasonable suspicion,
And what we're
is
talking about is
reasonable suspicion the same under the emergency exception as under, with regard to a past crime? Would it be a more liberal standard had he stopped him on Sturrow Drive where he still posed a danger, as opposed to in his driveway where he no longer did?
I think either way, what we're talking about with regards to reasonable suspicion is it is still a lower standard, obviously, than probable cause. And I think that the case law has been clear, both here and in the Supreme Court, that the standard under Aguilar-Spinelli, the two prongs, is somewhat relaxed in that circumstance.
All right, thank you.
There are no